Welcome, everybody, to our industry update this month. Thank you so much for joining us. We are so thrilled to have Pete Muccio back on again. I think of all our repeat guests, we haven't had a guest on as many times as Pete, and he's just
Oh,
always in high demand. And
and we're willing to abuse him.
right, happy to do that. So, Pete is an absolutely fabulous attorney who specializes in the area of landlord tenant law. And as anyone who touches that side of our industry knows, that is an ever-changing um, there are just so many changes happening with that as of late, and Pete is going to dive into that today. So, of course, we have Mr. Cox on as well, and we're looking forward to this discussion and hearing what Pete has to say. Thanks again, Pete, for being on, and thanks everybody for joining us. So, Pete, tell us what's going on in the wonderful world of landlord tenant law.
All right, we'll do. First of all, of course, Jill, Damian, thank you so much for having me on. So much fun to do some work with you guys and to talk about these things. So always enjoy the opportunity to sit down and talk with you. But like I was saying, kind of at the very beginning, I'm going to mix things up a little bit here, and I got a little bit of a rant, so I got to share a few things with you. So I'd say this: Ronald Reagan put it pretty bluntly in 1986. The nine most terrifying words in the English language are "I'm from the government and I'm here to help." Right? Um, the Colorado legislature should definitely consider that quote before they make any changes to the laws that impact property owners, housing providers, and tenants. Since 2020, the government has done more to interfere with the housing market in the name of providing protections for those who rent, when really they're creating policies that hurt the supply of housing and make it more expensive to be a landlord. The impact of the changes of this past year are going to be felt in Colorado this year and for many more years to come. And I want to give you like kind of an overview and a snapshot of what we're talking about. And of course, when I'm talking about these things, it's a snapshot, it's a perspective. It's not legal advice. You need to contact your own lawyer to talk about, getting legal advice. So this is just kind of a one perspective on things. But make sure you talk to your counsel before you dive into dealing with some of these issues. So I think the biggest alteration that's going to happen, that's going to impact the business of being a landlord, has to come from HB 25-1090. Now that bill on its face is not called rent control, but it does have an impact on what can be charged to tenants as a separate fee, specifically limiting charging back of taxes or costs to maintain common areas of properties and costs associated with a landlord's obligation to provide a habitable home. So landlords are also going to be limited in charging tenants for the actual cost of utilities for a tenant's unit, which can present an operational challenge for landlords that have a multifamily property, especially if the units aren't separately submetered. That's going to provide some big changes. So by limiting these terms, the legislature is not lowering the cost of housing for anybody. It's just dictating what can specifically be passed along to tenants as a separate fee. Landlords aren't going to be getting relief from these items, these obligations that they have to provide, but they're instead prohibited from providing those on to the as a separate itemization as a cost to the tenant. That's going to present some pricing challenges for landlords as far as how they're going to price their product, right? How they're going to price the homes for people and how they're going to break that down. And HB 25-1090 has some serious requirements when it comes to pricing, and that's going to have a big change on the market too. It's going to require landlords to disclose upfront the total cost of the lease and advertising. Now, this total cost, the approach is designed to promote transparency, which I think most people would agree, landlords and tenants, that's a good thing, right? So, but any markup that you're going to see is also going to have to be something that's going to be disclosed. So the purpose of that disclosure is so there's not these surprise fees that get added on, or that somebody's like, oh, hey, I think the price is one thing, and then it turns out that the price is something else because, I really wanted this price over here. So what that should do is it should really promote this hopefully a better marketplace in the sense that there's going to be a pretty direct comparison between rental A, rental B, and rental C, because you're going to be able to see as a consumer sort of the total price for what's going on. And I guess the landlord's going to be able to see also, hey, here's a clear idea of what's being marketed out there. It's really going to be interesting how that plays out, because that total cost means that if there's any fees that are a mandatory fee, that's going to have to be included in that disclosure. So it's really going to sort of make that marketplace and that sharing of information pretty widespread. It's interesting when you make a comparison to a bill that didn't pass that was going to restrict the use of algorithms and pricing, and how that was talking about using information. The legislature here is basically forcing this additional transparency of information so that all this information is going to be very widely available to everyone, because the consequences of not complying with this are going to be pretty severe, and it's going to be pretty easy for somebody to sue a landlord that's not complying. So basically, landlords are going to have to change how they're structuring their fees if they're and how they're advertising their fees, and that all goes into effect at the beginning of January. So that's a big shift. The good part is there's a little bit of time. Sometimes these laws go into effect immediately after they become signed, or there's like a 3-month fuse or a 4-month fuse. There's a little bit of a longer fuse, which is good because there's some big changes that people have to make kind of going into this, as far as saying, hey, how am I going to make some adjustments to what I'm doing? So that's a real big change. I don't know. I could keep going on ranting, but Damian, what do you think, man? Is there questions that pop up in your mind when you hear me talking about that, or?
Well, I mean, I haven't still wrapped my arms around that whole thing. In fact, I gotta be honest with you, Pete, that wasn't one that was on my radar. So
Mm,
it's concerning that I didn't real I thought we were through the brain damage last year, but obviously we're still going to continue to get brain damage. So
yeah,
yeah, so
yeah,
I guess I imagine you're probably going to spend some time on that one when we get into the session laws, or are you going to do more talking about it?
yeah. We could definitely talk about that some more. I mean, I think there's some differences as far as how this impacts people, and it kind of depends on, like, okay, what's your property, right? Are you talking about a multifamily property? Are you talking about one unit that you own and that you manage? But certainly this ability to advertise and how you advertise, there's no carve out exception here for anybody on this, right? So this applies to everybody. And I think it's just one of those things where you kind of have to be aware of it when it goes into effect, because it's going to sort of have this impact on how you're advertising. Otherwise, you're gonna end up creating a problem for yourself, and that problem is going to come in the form of a lawsuit.
That's
Um,
crazy. It's just
yeah,
crazy.
yeah. It's pretty wild. It's pretty wild.
Pete, a
Um,
couple questions popped up in chat, and
oh yeah.
we'll address those. And if anybody else has questions, if you could put those in Q&A, it makes it a little easier for me to manage. So one question was, so do the landlords have to list two prices, one with animals and the other without?
So I think with that, it's going to be really important for people to, if they have a pet fee, right? That's probably going to be a separate optional fee. You don't have to have a pet to move into a property. I mean, it's most people do have pets, right? But you don't have to. So you could have it so that it's an optional fee that gets added on. But if you're going to have something where you're selecting that as a price, it needs to be reflected in your total price, and you need to be disclosing what that price of that is.
Okay, another question was, if the tenant pays the electricity and gas bill, then we don't add this to the total cost?
Correct. Yeah. So if it's well, sort of. So yeah. It is correct in the sense that, hey, that's going to be a variable cost, right? But you're going to say that you're going to want to make sure that you include that they are responsible for that, but it is a variable cost, right? Because my electric bill is a lot higher right now than it is in the wintertime, and my gas bill is a lot lower right now than it is in the wintertime, right? So you don't have to have sort of that exact amount, but you do have to disclose if they're going to be responsible for it. The other thing is if it's one unit, it's pretty straightforward. That's probably going to be metered, right? And it's metered separately, and they're paying for that. When you're talking about dealing with multiple units, though, you're only responsible for your actual costs. So that creates challenges as far as, well, what if there's utilities related to common areas? What if there's utilities that need to be divided amongst multiple units? How does that work? And it doesn't look like there's a clear path for that to be done if you don't have separate metering, so where you would be able to pass those along.
And another question along the same lines, if the monthly utilities come out to $10,000 per year, can you just raise the rent $1,000 and include utilities in the rent?
Sure, easy enough.
And
Yeah,
that's
that
and
would.
that's
Yeah,
and that's what's going to happen, right? I mean, the utility
it's
is going to be 10,000 a year. They're going to raise it $1,000 a month, so the landlord makes sure that they don't get harmed by the utilities. Of course, then the tenant's not going to turn out lights or do all that stuff. What a mess.
well, exactly. And that's one thing. You look at it. There's been a large movement towards moving towards being conservative with resources and utilities, and trying to shift to more efficiency. If you're not paying for it directly, is that going to promote efficiency? Absolutely not. People are going to be leaving the lights on, right? They're going to be saying, like, you know what, it's bath day, because every day is bath day, right? They're going to be just using
Or,
more water. It's
I
like,
like to take 2 hour showers, and I don't really care that I use more water. That's
yeah, yeah. You're
the
creating
amount's the
this.
same. It doesn't matter.
Exactly. You're creating this problem. And I don't know if that was the intent of this bill. I'm not sure that people were saying, "Hey, yeah, let's really prevent people from passing on utility costs." But when you look at the way that some of these things are worded, it's like, wow, this creates some really big problems here for people to sort of sort through. And how do you do this in a way that's fair? And the thing is, if you say, well, hey, look, these other systems were a really fair way to deal with that, how does that hold up? I don't think you really know until it gets tried.
Yeah, and that's the bigger issue is that how much do you want to spend to find out?
Exactly, exactly. And it's I think the challenge, we've got, I'm sure there's probably a bunch of brokers that are on the line here. And if you're talking about that, you've got to have your lease approved by a Colorado attorney, right? And what attorney is going to be saying, hey, yeah, let's roll the dice with this.
You don't think so?
Hmm. Yeah.
Yeah.
We had another question that came through from Latanya. When do we disclose these fees in the lease agreement or in advertising? Do we suggest a fee breakdown sheet?
So the answer to that one is yes. So you're going to want to disclose everything in your advertising, and then you're also going to disclose it prior to the signing of the lease. And so, like, I think there's been some discussion of what's called like a Schumer sheet. Don't say that 5 times real fast. It's gonna get messy. Um, but where you have sort of this breakdown of the disclosure of the fees on the front page, right? Saying like, hey, here's the breakdown. Here's what all these fees are of lease. And so I think that's going to be a pretty commonplace thing that you're going to see in leases.
Awesome.
Yeah.
Cool. That's all the questions we have for now, I think.
All right. Well, you know, with don't want to get too political for people, but with the concentration of one party at the federal level, there was some assumptions that the Federal CARES Act might be repealed and or clarified, because there's a lot of different jurisdictions have different takes on whether or not that applies. And for some of you, they're saying, "Hey, what's the CARES Act? Wasn't that like a 2020 thing? Isn't that done?" Yeah, it should be done, because it was like kind of this emergency limited protection. But some judicial minds have said, hey, in multiple states, not just Colorado, have said, hey, you know what, this still applies. Colorado said, hey, it didn't expire, so it's still in effect. Because of that, that means if you have a property with a federally backed mortgage, if you have a tenant who is on a voucher, you are dealing with a CARES covered property. If you're dealing with a CARES covered property, what does that mean? It means that you can't give a 10-day demand. You can give a 30-day demand when you're talking about non-payment of rent. 30-day, 10-day, is that really a big deal? well, yeah, it's 20 days, and it is a big deal, because there are some people who don't just pay their rent when it's supposed to be done. They'll wait to the very last moment to pay it, and that's a big difference when it's 10 days or 30 days as far as the window that you're dealing with. So, um, Colorado passed a law. It was HB 251240 that said, hey, you know what? The CARES Act, whatever happens at the federal level, if that gets overturned, it's okay, because in Colorado, we're going to keep it at 30 days. So everything that's federally covered, doesn't matter what happens, even if it gets repealed, it's still going to be a 30-day issue if it's going to qualify as what was a CARES covered property. So that's a big deal.
My
Yeah,
gosh, I didn't even know that one passed, Pete. You're kidding
yeah.
me, really?
No, no, I'm not kidding.
What was
Yeah,
the
yeah.
logic in that?
Well, I think some people thought that that was a good idea.
That's
Yeah,
the logic, is that
yeah.
they thought it was.
They thought it was a good idea. They thought, hey, this is a protection that's really important. And I think when you talk about, this idea of like these things get done and they're going to create this harm for Colorado in the future. Let's say the CARES Act goes away. Okay. And you're an investor and you're coming up and you're looking at, hey, I've got a comparison between Colorado and any other state that doesn't have this 30-day restriction on it. Where do I want to do business? Right. I think it becomes like there better be something else that's great that's going on in Colorado. And don't get me wrong, there's a lot of great things about the state, but I think that it's a little short-sighted because you're really setting up this uneven playing field when you're comparing our marketplaces to other marketplaces. And you're really banking on the things that are really a draw for Colorado will continue to be a strong draw. And I think that's an issue, right?
Well, what comes to mind for me is that, in the past, and a lot of these brokers, I'm sure, have had clients that have said, "Hey, I bought my starter home 5 years ago, and now I want to move up, and I think I
Hmm.
have the ability that I can actually buy a new home and leave my other one as a rental. And if they leave that loan in place, that's a federally covered property 9 times out of 10.
Yeah.
And that means
Yeah.
that those people that are new to the landlord business and are just trying to get investment into real estate are going to have this onerous extra 20 days of sending notices.
Yeah, and let's keep talking about that example situation. I think they have that extra time period. You've got the mortgage on the property. You probably need the rent to keep paying the mortgage, right? Because you might have some other expenses if you moved into a different home. So you create the situation where you're really financially strained if you're not getting the rent in, right? And that's going to make it tough when you're looking at that math of saying, hey, yeah, I could be a landlord. I could maybe, have this property, use this as a way to build wealth outside of other, other areas. And I think it oftentimes it was looked at as, hey, maybe this is a good lower risk way to approach these things. And, I think it becomes a harder sell for somebody for sure
Well,
at that point.
if assuming they even know about it, right? I mean, that's part of
Yeah.
the problem is a lot of them don't even, because you got lenders, they're from out of state or whatever, don't understand. And they say, hey, you know what? You could do this and you could build some wealth in real estate by keeping your property as a rental.
Hmm.
Add the 20 days and then compound that with the laws that we saw last year that said, or in the previous years that said that the tenant can pay up until the day they bang the gavel, and you have to give them so many notices and you have to do it twice and all this other crap that goes with it. It just, you're making it, I mean, you're looking at what, 90, under those circumstances, maybe 90, 120 days to get somebody out.
It's possible. Yeah. Yeah. I mean, it it's a lot slower than what it used to be. And I tell you, I just got back from a conference. I say got back. It was in Denver, but I attended a conference last week, and talking with some attorneys, landlord attorneys from around the country. Um, there are other states where it's a lot longer than that to deal with like an eviction. Yeah, we're talking like years. So uh, there's some comfort in, hey, it could be worse, but it's cold comfort, right? It's not like, yeah.
I'm curious, in those states, do they have investment? Do they have housing shortages? Do they have, I mean, I bet you they're a prelude to what's coming for Colorado as far as housing crisis and affordable housing.
Yeah, yeah. Well, the one that I'm thinking, they got housing problems, right? There's a couple of densely populated states out east that it's going to take a long time to go through that eviction process. So, another thing about that CARES Act sort of being codified at the Colorado level, there's another little nugget that's in that bill, and that's requiring landlords to cooperate with rental assistance. Now, that might not sound like a big deal, and I think for a lot of people, it's probably not a huge impact. But it does create this limitation on flexibility. And I think that's one thing that we've seen as far as, you compare last year's the restrictions on being able to deal with a non-renewal, right? And having to evict with just cause. It's an elimination of flexibility of what to do with your property. Now, when you're talking about, hey, look, you have to accept rental assistance, that's sort of another elimination of some flexibility that you have. And let's be clear, people who are renting a property want the rent to be paid. They don't want to be going through the default process and everything like that. So when we're talking about that lack of flexibility, talking about it when you're dealing with a difficult situation. And I got to tell you, those difficult situations do come up, right? Where maybe there's some other conflicts that might be going on that create some challenges between the landlord tenant relationship. And, there's just situations where landlords could be faced with a difficult choice of, hey, look, do I take this money or do I end this difficult relationship that I have here with somebody? Well, if it's a rental assistance that they're being forced to take, they're not really even going to have a choice at that point.
Wow, that's crazy.
Yeah, it's pretty wild. Um, so another topic that the legislature did turn their focus on was dealing with protections for victim survivors. And I think one area that it's a difficult topic to deal with, and it's something that the legislature hasn't dealt with in a while. But I think it's important to sort of understand where the law was prior to this, and then sort of looking at what the protections have been. But before I jump into that, I don't know. I saw there were a few other questions. Were there questions that popped up that were related to any of this? Um,
I think there's a couple regarding some fees, and you want to read them?
Yeah, give me just a second here. So I'll just kind of go work backwards since we were just on this topic. So Latanya says, just so I'm clear, a Colorado Care property includes those accepting vouchers plus any federally backed loan, FHA and VA. Those you have to give 30 days versus 10 simply because of the type of loan.
Correct. And I just to clarify, it's an or. So it doesn't have to be a voucher and those things. It's an or situation. So if they have a voucher or if it's the federally backed mortgage, then it is a 30 days. So that's right.
Perfect. Can the landlord make security deposit deductions? I assume they can within reason, but just wondering if there are nuances to be aware of.
Well, that's kind of like jumping ahead, ripping up the script a little bit. There was some changes related to the security deposit law, but we'll come back to that in a little bit.
Perfect. And Wendy says, I've never paid the electric and gas in my unit, so I don't know what the costs are because they are paid by the tenants. It's not shared with other units, so I don't need to have it in the total cost for the ad.
Well, I think you need to disclose that there's a variable cost, because when it's something that is variable and specific to utilities, you don't have to have that specific number. But if the tenant's going to be responsible for that as part of their rent, you're going to want to disclose that they're going to be responsible for that.
And what about cleaning fees when the tenancy is over?
Again, we'll come back to that on the security deposit revisit.
Okay.
Yeah.
There you go,
And
Pete. Lead on.
All right. All right. Okay. So the difficult topic of dealing with some of the domestic dispute issues that can pop up, right? So this is not new that there have been protections related to tenants who are a victim of domestic violence, and that could include situations such as stalking. It's a pretty wide issue. And the laws that were previously on the books basically were designed for if a tenant was to leave a property. And this new update to the protections now is a change in that it contemplates that a tenant could stay at the property. And so there's some clarity around dealing with the situation where if a tenant is a victim, and what if the perpetrator is on the lease, the clarity that you can change the locks to prevent the perpetrator from coming back in order to protect the victim. That's something that was fairly common advice to do, but it wasn't necessarily super clear, and that wasn't in the statute at all, actually, that could be done. Um, so, but part of dealing with this idea that somebody's remaining in the property is giving them some additional protections and rights to secure a payment plan if the incident had an impact on their ability to make payments. And so that payment plan could stretch up to 9 months. And it's also something where the previous law, tenant had to get a police report, they had to have a restraining order, they had to have a victim's advocate talk about them. Well, now the tenant can self-attest, and they can say, hey, I'm a victim here. And so what that does is it gives the landlords very limited abilities to challenge those things and to sort of raise issues with that. And so you could see scenarios where, if somebody was not being completely honest, that they could try and take advantage of this law, which would be unfortunate because this law is in place for a reason, to give protections to those that need it. But it's an area that really puts a financial burden on landlords. And I think going back to your situation of the, um, you know, maybe they're a voluntary landlord. I was going to say involuntary landlord, but they're moving out of one house and going on to their next house. This is the math of having a tenant has just gotten a little bit more complicated, where you really need to have sort of a bigger cushion to deal with the unexpected things that not only might happen with the house, but might happen with the tenant, right?
Yeah.
And being able to make sure that you're in a position to sort of manage that. And I think that's important to sort of be aware of going into that. So if you've got people who are trying to guide landlords into, like, potential landlords, like, okay, hey, you want to go through this, make sure you understand, hey, here's some of the risks that could be associated with this, because you don't really want to be surprised, right? You want to try to be prepared for those known unknowns. But yeah, there's some other details along that, the with dealing with the victims protections. There's some pretty tight timelines for landlords to offer repayment plans, um, like 3 business days. And then the tenant has the ability to accept that or counter that or reject that. And the tenant has the ultimate say as far as what the payment plan that's going to work. And there's just not a whole lot of pushback that the tenant could have there. So it's it's a big deal, and it's a big change. It's also something that can pop up at any time during the tenancy. When I say any time, I mean you could be dealing with a tenant who is going through an eviction process. This could come up. This could have an impact on that process and dealing with that. It's there's so many different variations of issues that can come up surrounding it. It's one where you really have to work through very carefully, and again, something to definitely talk through with your legal counsel if you're running into something like that.
That's crazy. I mean, you had warranty of habitability, just caused eviction, and now the 30-day notice with CARES Act, and couple it with this. It's hard for the little guys.
It really is, and I think that's the thing, is that you look out there and you say, okay, who makes up the majority of the landlords? Is it Big Co? No, it's not. It is the little guy. And I think it's really becoming more difficult. With that, I think that also creates a real opportunity for the broker that's saying, hey, you know what? I do property management. You want to do this on your own? Probably not. You probably want the broker's help that's going through the trainings, that's got the experience, that's able to sort of navigate these things and keep on top of this stuff. Because it's a lot. And the part-time landlord um, is really they're really gambling if they're not doing their work on keeping on top of things. And that's all of these bills have negative consequences for people that violate these things, and part of which is paying the attorney's fees for the tenant, um, which is not good. Speaking about negative consequences, there's even more.
There's
Um,
more?
there's more. There's more. So there was a bill that expanded the government's authority to get involved in a situation where um, there's a problem at the property. The property is not being maintained the way that it should be. So that could happen at the state level. It could happen at a local government level where they could come in. They could effectively take control of the property and run the property as they see fit to deal with those problems. And that's a big power. It's a big expansion of power. And I like to point to an example of a situation because people are like, okay, well, that seems like it's responsible. It's, hey, if a property's not being done, the government can come in and do some things. And you know, yeah, on one hand, it does seem like, hey, maybe that's a good protection, but I've seen governments try to put property owners in jail because of weeds, right? Now they didn't, I think the underlying story was that they didn't like the use of the property and they were using that as a guise to put pressure on the property owner. But with these significant government powers that come out there, there's also a significant possibility that they might be misused. So hopefully that doesn't become the case. And, certainly if everybody who's on here today, as long as they're maintaining their property, it's probably not something that they really need to worry about. But it is another thing that is out there.
Hey Pete, could you remind everyone or tell us who do you represent? Do you represent the little guys? When would these guys reach out to you? Who are your clients?
Yeah.
He represents us, honey.
I do know that. And
Yeah,
we're
that's
little guys.
well, the empire that is the your family. I mean, it's huge, right? So you don't come in the Castle Rock without first talking to Damien and Jill, all right? So no, so we work with everybody from people that have one property to people that have hundreds of properties, to thousands of units. So it's really a wide range. We represent landlords, we work with brokers, um, and we very rarely have gotten involved in representing tenants, more so on the commercial side, but it's not something that we're typically able to engage in because we do so much work on the landlord side of things. So, um, but
And
yeah,
if
thank
people
you.
want to reach out, what's the best way to contact you
You
or
know,
your firm?
yeah, yeah. So if they go to our website, which is the initials of our firm, which is TSM.law, and if you go there and there's an intake form on there where they can go and click on there if they are interested in becoming a client and going through our process that way. So we typically will set up a screening, and we do a screening and set up a consultation where that's a paying for your time consultation. But yeah,
Awesome.
And
yep,
and I will say this, you guys have a lot of resources on your website for those that are your clients that is really fantastic. So if you do retain Pete's law firm, check out the website for some resources that you would have available to you as well, because it is very helpful that you might not have to contact them for at least some of those things.
yeah, yeah. We do a lot of So we do a regular monthly webinar where we're talking about kind of hot topics that pop up and dealing with those issues. We have a lot of forums. We've got some articles on there that kind of dive into some of the nuances of all the challenges that landlords face. So yeah, thanks guys. Security deposits. Want to
Oh,
talk about
goody.
that?
I
Yeah,
can't
yeah,
wait.
yeah.
I'm
I
so
know there are a
excited.
couple questions previewing that. So I guess the good news is this bill looks nothing like it originally did when it was first proposed. And if you heard anything about that first bill, it was pretty scary. It was like, what? Where is this stuff coming from? And so it's been dialed back quite a bit, so that's good. Even to the point where there's a nugget. I think probably one of the best things that might be in here for landlords is that there's this carve out that you could return a deposit to a tenant via ACH if the tenant opts in for that, which I think is fantastic because the number of disputes that can happen as far as dealing with, oh, my check got lost in the mail, or somebody's moved from point A to point B, or whatever. There's a lot of disputes that can happen around those things. Um, uh, the operational shift is really, I'd say, it's going to be a big one on a few things. Um, when it comes to damages, you're not going to be able to just charge somebody because it's looking messy in the unit. It's got to be dirty to the point that it's beyond normal wear and tear. That's going to be a big issue, I think, as far as dealing with the impact of, accounting for the deposit and making sure the property is cleaned up. Um, there's now going to be this requirement of sharing documentation to support the damages with the deposit. Again, something that was a good practice if you were dealing with the accounting. Hey, you know what? If you're given the support right up front, that's probably going to cut down on some issues. So maybe not the worst thing, but something that's going to be a little bit of a modification. There is also going to be this opportunity for the tenants to demand an inspection both before they vacate the property and after they vacate the property. Not sure how often this is going to be utilized, but it's something that could be, could be used, and it could force additional communication and interaction, which is interesting because there was a point in time where it was pretty common to do a walkthrough. I feel like post 2020, that kind of changed, right? I think it was a little bit more, people kind of went away from that. Now, certainly taking pictures and documentation, that's always been a big deal. I think the premium on making sure that people are getting documentation of the condition of the property prior to renting the apartment, still a big thing. I think it's always been a big thing, but I think there's even more importance that's put on that. So yeah, some tweaks there, some operational changes for people. One other thing, this was an interesting one. There's in Colorado, there's a limitation on source of income discrimination, right? And there was a bill that got passed. It was called SB 25167 that gives the ability to provide a preference to employees of public school districts. So I think the thing that's interesting about that is it basically kind of gives a carve out to say, hey, look, you know what? This is going to be some direct housing for people that might have a hard time getting housing, that it's important that they're in the district, that they're providing a service to the community here. And so it's kind of one of those sort of interesting carve outs there that might, promote some other forms of affordable housing in different places in the state, to be able to say, hey, look, I'm going to give a preference here for dealing with an employee of a public school district. But yeah, there was a lot of stuff this year. I mean, this is just kind of pretty good snapshot of what we're talking about in some of these bigger impact bills. But yeah,
It's crazy because
it
last
was
year
a
I
lot.
thought, what could there possibly be left? But apparently
Oh
that's
yeah,
a lot. I mean, because last year
yeah,
was last year and the year before was huge. I mean, just some major shifts.
It was, and this year, I mean, I think I've been told that part of the challenge with the budgets and everything like that, there was just a lot of things kind of hit all at once, right? There's just this flood of these proposed bills, and a lot of them went through. There's some things that didn't pass. Right, there was a bill proposed related to juries in eviction cases that ended up getting withdrawn, and there's the algorithm bill was not a bill that became law. So it's interesting, what's going to happen next session. We talked about 1090 and not really lowering the cost of housing, but if rents are going up, if there's this additional transparency, and if rents go up, but because of the inclusion of fees, what's going to be the next argument on that? There's always this talk of rent control. Is rent control going to come back and be raised? But it's a concept that just doesn't work. So, it was nice to not see that in the picture this year with everything that was thrown out there. But they're really trying to look at these sort of operational shifts, right? When you're talking about like, here's how you can advertise. Here's what you can include in the rent, as the sort of the separate fee. It has this sort of like, um, it has this control aspect to it, right? Because it puts these limitations as far as what you can do with property. That lack of flexibility.
Yeah, I mean, there's 7 questions that I think we probably need to get to at some point, Pete. But I did want to ask you this. Obviously, it's hard to know what the impact of a law is in the year that it's been passed, particularly when it
Yep.
hasn't gone into effect. Luckily, they stopped doing the safety clauses on these damn things because that was a bear. But you have now had a year of experience with the ones from last year, or 2 years
Mhm.
experience from the ones before. Are you seeing the impact on landlords from those bills?
Yeah. Um, I'd say talk about the just cause issue. I think I think a lot of people become aware of that, or they become aware of it when they need to suddenly say, "Hey, well, I can just non-renew somebody," right? And it's like, no, that's not an option for you, right? You've got somebody that's been a tenant for over a year. The relationship has changed, right? You're now in a very committed relationship, and you're kind of stuck with each other for a long time now. So yeah, that's definitely had an impact. We've seen, you see some things kind of roll out, and you see sort of a blip impact as far as like if there has to be a change to a notice using a right notice. This domestic violence bill has a requirement that you have to advise the tenants of that. In the eviction filing, it's got to also be in the eviction demand. If the demand is served now, it's a requirement that it be in the demand. That requirement went into effect August 6th. So, for people that didn't,
Yesterday.
very yesterday,
Yesterday.
yeah. So very timely on this call, right? So if people are like, well, hey, I'm using these old forms, these 3-day demands, it's like, whoa, wait a minute, did you say 3-day? Those don't exist anymore. Um, it's so definitely when you see sort of those updates, and that has that sort of impact. Other things, I think, the warranty of habitability changes, definitely seen an impact there. I mean, we've seen a steady increase as far as like people raising challenges related to the warranty of habitability, as far as throwing things out there. The service piece of the demand has just made it more complicated for people to initiate that eviction. Or the start of the eviction process, which is dealing with the default. And so, that's really taken a lot of time for people. And it's different people that have that impact, right? If you're not near your property that you own and manage, it's maybe a big effort to go out there a couple times. And so if you're owning multiple properties that are, maybe throughout the metro area, or, in different parts of the state, it really becomes some operational challenges that get presented with that. And just even if you're talking about one community, it's a lot of work that people are, if they're, especially if they're serving multiple notices and having to make multiple attempts at dealing with that. So I think all these things do add up to sort of this additional complications, and people are trying to get things right, right? And they want to get things right and get them done the correct way. And it's just it's there's just more of an opportunity um, to have a mistake, which creates an opportunity for delay, which creates more problems,
Yeah, more cost.
more cost. Yeah. Yeah.
All right,
Are you ready for a few questions?
let's do it.
We'll try to rapid fire here. Are there any regulations that specify the minimum number of days notice required for a rent increase? I have tried to keep it reasonable, just wondering if anything by statute is required.
Yeah, there are some restrictions on that as far as the amount of time that you need to give. I don't have the site right off the top of my head, but yes, is the short answer on that. And there is a limitation on that. Yep.
Can you provide the citation for the victim update and law?
Yeah, it's HB 25/1168 is the House bill.
Okay. And let's see. Oh, I think that was the same.
It's the same one for the bill number for the DV bill.
Yeah,
Oh, that's the DV bill. Yep. Yep.
Yeah.
perfect. What if a lease goes past the first of next year and the tenant is being charged a flat fee for water, sewer, and trash? Will that fee need to be dropped off after the first of the year?
Conservatively, I think it will, because there's nothing here in this bill that talks about these things dealing with the leases. It's talking about these things being charged. So,
Better off
yeah,
just raising the rent and paying the
it's
fee.
yeah. Once you can raise the rent, right? So,
Yeah, once you can
um,
raise the rent.
yeah. But I don't think you're going to be able to pass on that flat rate um, going forward after January 1st.
Pete, does your law firm have a boilerplate rental lease updated with the new laws integrated for purchase?
You know, I do have to like just take umbrage with the use of the term boilerplate, but I know what you're getting at. So we do have
It's
a lease.
boilerplate. Do you know it?
Just chat
we
GPT it.
Oh
we do
God. Oh God.
we do have a lease product. We are finalizing our updates for the compliance for this current session. So we're getting pretty close to that. So yes, that is something that we do sell and should have finalized here in the very near future. So
Okay, can you return security deposits via Zelle?
well, it is so you could, yeah, sure, you could do that. But here's the thing. The statutory protections talk about mailing. They talk about ACH, right? It's not specific to one of these third-party payment transfers, Zelle, Venmo, whatever, So the thing is that you have to be cautious with is, hey, this could work if everything goes smoothly. They get they get the payment, goes fine, it's great. If there's a dispute and you say, hey, I did it through this payment method, is that going to be good enough? Logically it makes sense. You're like, hey, look, this works. I've got their information and this is what I did, but there could be some risk there associated with it if things don't work out. And again, it's easy for me to say, hey, when things don't work out, because that's a lot of what I deal with. I don't typically get those phone calls where everything's going smoothly, right? So it's a risk.
Does the landlord need to pay for the before and after inspections?
Oh yeah.
Okay. And I'm going to jump over here into chat. There were some questions earlier. Would it be reasonable in a fourplex to add the actual expenses the following month to the rent charge? So, for example, you have a 4 unit plus a common area divided by 5, passed along to pass along a fifth of the utilities to each of the 4 tenants due the following month.
You got some problems there when you're talking about the common area because you can't pass on common area charges. I think the other thing is that like you're talking about like, are you dividing things up? You're limited to the actual cost, right? So I get it, logically you're like, oh, we got 4 units, we're gonna just divide by 4. It's like, well, what about the one person that's taking a bath every day and the other person that, man, they're like once a week in the showers, you're like, ah, come on,
Once a
man.
year, pig pen.
Yeah, there you go. Yeah, exactly. That's you got some challenges there with that. So some sort of a sub-metering solution is going to be very helpful if you're going to want to pass those direct costs on to the tenant.
Going back to the CARES Act, does it mean that you cannot even charge late fees after the 30 days?
No, that does not impact late fees.
However, if they don't pay their late fees, you can't evict them.
There's that.
From a screening process standpoint, what are valid reasons a landlord can reject a prospective tenant?
Oh, well, there's a lot to that question. So there's some laws that were passed a few years ago that talk about like what you can screen for, and essentially you can look back for criminal records, but you're limited on your time period of look back. There are a few carve outs as far as dealing with that, where you're talking about dealing with things like murder, if there was a conviction for something like that.
But not arson. But not arson.
But not arson. Yeah, you got this weird like it's unusual why that's sort of excluded. The other thing is you have limitations on, it depends on, is your tenant subsidized? If your tenant's subsidized, they have a voucher, you can't run their credit. Period. So your Colorado has it so that instead of just treating everybody the same, you actually treat them differently in the sense that it depends on how they're coming to you, which is a big shift that happened a few years back because so many times people are like, I got to treat everybody the same. It's a fair housing issue. I got to treat everybody the same until the legislature says, actually, you don't treat everybody the same. There are some limitations here. So.
I think we've got one more question here. If your property is being managed by a professional property management company, can the landlord rely on the charges to the tenant being reasonable and supportable in court?
I hope so, for the property management company's sake.
Yeah, I mean that's where the claim goes, right? Is that if they can't support them, then the landlord turns
I
into
lost you, Damian.
manager. Yep. All right. What's that? Can you not hear me?
Can you hear Damian, Jill?
Yep.
Maybe I lost. Maybe it's me. Hang on a second.
I was going to say,
I'm like,
oh my God, nobody's ever accused me of being too quiet.
Turn up your bell tones, Pete. Okay, I think we got through all the questions.
Good.
Pete, that was incredible. Thank you so much for your time and for sharing your expertise. And this is such an important update for all of us that are in the business of real estate and have rental properties and have clients with rental properties. So a lot of big changes out there, and we can't thank you enough for your time today.
Yeah, not a problem. Thanks, guys. Sorry for the microphone there. I was like, Damien, your lips are moving, but I can't hear you.
I'm like, what is going on here? I don't even know if I finished my sentence. I got so thrown off. All right, guys. Well, thanks so much, Pete. As always, it's always great to have you on.
Yep. See you guys.
Yep, definitely. Thanks everybody for joining. If you find value in these, the greatest way you can support me or your Chicago title sales rep is with a title order. So please reach out if we can close an upcoming transaction. Thank you so much, and we'll see you on the next one.